Mr. Chief Justice, may it please the court, my name is Brad Levine, and I, along with my co-counsel, Charles Hatley, represent the petitioners of the Hope political party. May I reserve 2 minutes of our time for rebuttal?
Yes.
There are two issues before this court. My co-counsel will address whether a conspiracy to marginalize citizens for their political affiliation violates 42 U.S.C. Section 1985-3. I will address whether a content-based restriction on the expressive conduct of a political party requires the O'Brien standard of intermediate scrutiny under the First Amendment. The position of the petitioners is that the lower court erred in granting the respondent's 12b6 motion, and we pray for this court to remand this case with instructions to apply the O'Brien standard of intermediate scrutiny for three significant reasons. First, it does not further an important governmental interest for respondents to entrench the dominance of a political majority in defiance of the will of the people. Second, respondents' scheme to control the outcome of the ballot initiative is a content-based restriction meant to suppress the petitioner's freedom of expression. And finally, Your Honors, even if other forms of expression remain open to petitioners, the law does not require that they substitute their First Amendment protection for more burdensome alternatives.
So in the abstract, can you have a supermajority requirement when it comes to legislative initiatives? I mean, is that something a state can do in the abstract? Well, forget what happened here, but is that okay, or does that have speech suppression problems?
Justice Sutton, a supermajority in and of itself is in no means a problem. And that is not the position of the petitioners. Certainly, as respondents will note, you see a supermajority in different facets of the government. However, where it becomes a problem is where you find that it has suspicious timing, as seen based on the facts in the claim. What we have are a group of citizens who formed a political party with the intent of getting on the ballot initiative and reforming electoral college votes for the presidential election. In response to that, the respondents, on behalf of the Republican Party, amended the Constitution to include these content-based supermajority requirements and masqueraded the amendment as content neutral when it is in fact content-based.
It sounds to me like political suppression, not speech suppression, and there seems to be a difference.
Your Honor, this court in Meyer v. Grant broadly acknowledged that when citizens wish to engage in the political process, it implicates the First Amendment. And certainly there are both personal and structural restrictions that can be at play. When the government passes an amendment such as the Scranton Amendment, it would be a structural limitation. However, it can still have a chilling effect on the speech and conduct of the citizens. In this case, that chilling effect would be their desire to have expressed their views through voting on electoral college reform. And of course, as my co-counsel will address more fully, not only was the Scranton Amendment passed in this fashion, but the respondents, the governor, the party of the Republicrats, and the police chief all got together and conspired on how they could marginalize these particular citizens. That is both subject matter-based discrimination as well as viewpoint-based discrimination, Your Honors.
What law that has ever been passed does not contain viewpoint discrimination? Isn't that the whole point of a law? It is one view out of two or three or four, and that view becomes the law. Isn't it really strange to start saying, oh, shoot, we better apply strict scrutiny every time a debate is resolved through legislation?
Your Honor, the position of the petitioners is that, of course, when a law is passed, it's going to implicate to some extent views. However, it is when you have the particular facts in the context of a case such as this one where it becomes a problem.
That really is the timing point, right?
Correct, Your Honor.
Just to clarify the issue regarding timing, is it your position that had the initiative or the legislation been changed closer to January when the votes were collected, you wouldn't be here today, but rather the problem is it was closer to the November voting date? Is it truly just a timing issue?
It's not just a timing issue, Your Honor. It's the overall chilling effect on the quantum of speech. Most of the cases that the respondents are likely to cite from lower courts, for example, Initiative and Referendum v. Walker by the 10th Circuit, they contained supermajorities that were already in place. That is a fundamental difference, Your Honors, in this present case. And the concern of the petitioners is not just the impact on the individual members of HOPE, but furthermore, on the effect it will have to spur public debate on this issue for future reformists who might wish to change the ballot. And furthermore, Your Honor, the important policy issue here that petitioners wish to bring to the attention of this court is not just the chilling effect, but our system of democracy is based on checks and balances, on the separation of powers. Here, we have a dominant state where the Republicans are in both houses of Congress and the governorship, to the extent where the governor is one of the named respondents. And there is no other source for the petitioners to turn to other than this court and the lower courts in order.
And other than the next election.
Your Honor, certainly in the next election, the voters could come out and vote on the issue. However, voters are discouraged from doing that.
So let's say that's how it does play out, that this lawsuit had never been filed. They do the 75% requirement. It has its effect. They can't make the change. And the tables do turn. The opposing party now is in control. And this time around, the opposing party says, wow, 75% supermajority, that is just too high. We're going to reduce it to 60% or 51%, and we're going to make it super minority, 45%. And they all have political reasons for doing it, to further their political ambition. I take it the same constitutional First Amendment claim could be filed there, right?
Your Honor, only if it was done with suspicious timing, where it was paraded as content neutral as the Scranton Amendment, when in fact the purpose was discriminatory. If those...
how about this timing thing? I mean, is it not a little suspicious that the framers of the U.S. Constitution, in putting together their handiwork, said it's going to require a 3/4 majority of the states to overturn our excellent good work? That strikes me as the worst timing possible. The very people that created the Constitution made it almost impossible for anyone to change it. But it never occurred to me that you could undermine that with a free speech claim.
Your Honor, if you're talking about amendments to the Constitutions being passed through both houses of Congress, that's a checks and balances on the government itself. Here, this restriction, Your Honor, is directed at the people. That's why the people need to be able to turn to this court and the lower courts to be able to act as a system of checks and balances. There is no other source for them. And Your Honors, conduct is no more expressive in our democratic society when people wish to go to vote on an issue of importance.
From a practical standpoint, is there any impact from the fact that this 3/4 super majority only applies to this particular initiative? Does that play into this at all? Should we consider that in any fashion?
Yes, Your Honor. On page 20 of the complaint, this court will note that the plaintiffs allege that it was specifically focused on the Electoral College reform. In that sense, it was subject matter based, but also directed to the viewpoint of the petitioners, and that should be considered by this court.
Does that fit in anywhere in the O'Brien standard?
Yes, Your Honor, because if we look at the elements of O'Brien, may I have an opportunity to respond and conclude, Your Honor?
Yes.
Yes, go ahead.
If we look at the elements of O'Brien, the second and third elements in particular, it has to further an important governmental interest, and it can't be related to the suppression of free expression. This was passed with the intent to suppress their free expression, and for that reason it would fail the O'Brien standard, and this court, therefore, based on these facts, should find that the O'Brien standard applies, and we pray that it remands this case for decisions on those merits.
Thank you.
Thank you.
And the best team was the petitioners, which might have had the harder side of the argument. So that's Brad Levine and Charles Hatley. So congratulations to you guys.
Mr. Levine, I can only say you're unflappable. I mean, we couldn't get a reaction out of you one way or the other, and I wish if you tell me what supplement it is you take, what you do to achieve that, and you don't have to do it publicly, but I'll benefit from it for sure.